Good afternoon. My name is Gene Policinski. I'm Vice President and Executive Director of the First Amendment Center. Very briefly, we are a nonprofit. We do not lobby or litigate, but we are about education and First Amendment, and we do a number of programs relative to judges and journalists, and we feel that obviously an independent judiciary is probably the best defense for all five of the freedoms in the First Amendment. I will tell you that I'm most comfortable quoting Madison, but since he and Hamilton, with a little help from John Jay, cooperated on the Federalist documents, I can shift, I think. And Hamilton took great pains, I think in 78 and other parts of the Federalist Papers, to point out the value of an independent judiciary, the necessity of it really for very basic freedoms in this country. And so with that, I would move to introducing our panelists. Forgive me, just in time. And I'll do that by title only, and then we'll ask for opening remarks from each of them. You have full bios in your packets, I'm told. Also, one housekeeping thing, there is a microphone here, so when we do go to Q&A, if you would, the sessions are being recorded. Those of you, as we used to say, with outstanding warrants should take heed. But other than that, please move to the microphone and identify yourselves when you ask the question of our panel members. We have the Honorable Joan Kessler, Judge of the Wisconsin Court of Appeals, District 1. The Honorable Vanessa Ruiz, Associate Judge, District of Columbia Court of Appeals. Bert Brandenburg, who is Executive Director of Justice at Stake, isn't here, but suffering from laryngitis, and filling in for him is Jesse Rutledge, who is Deputy Executive Director of the Justice at Stake campaign in Washington, D.C., since he is not in your packets. Let me say he tracks and analyzes special interest threats to fairness and impartiality in America's courts. He develops proactive messages and public education campaigns to deal with those issues. He has written commentaries about judicial politics in state and national media, including the ABA Journal Governing and the National Law Journal, and in June will assume a new position as Vice President for External Affairs with the National Center for State Courts in Williamsburg, Virginia. And then we have also Ron Tabak, Special Counsel for Skadden Arps, who is coordinator of the firm's pro bono program. And I have to say, I looked up the Google entries, and there are 18,500 as of this morning. So, forgive me. With that, Judge
And
Kessler.
yet, I'm the dishonorable Ron Tabak.
I didn't get too deeply into the content. But Judge Kessler.
So Ron obviously gets the title of Google King. My husband says I have to start with a joke, and so since he's sitting here and will give me a hard time if I don't, I will tell you one that maybe has a little to do with what we're here for. There's a story in our state about a judge in a rural area. I suspect this judge makes it to lots of rural areas, but the judge had a terrible time with the rules of evidence, and it just drove the local bar nuts. And so they finally had a meeting with him, and they said, "Judge, what are you doing?" He said, "Deck of cards, and I flip. When you say object, if it's red, it's overruled. If it's black, it's sustained." And they thought, well, gee, maybe we can do something about this. And so they put their heads together and decided that they would buy him a well-known publication on the rules of evidence, which they proudly presented to him. And they said, gee, we'd really love it if you'd actually try and use this. And so happy to do that. I understand, why you want me to do this. And a couple of months went by, and it was worse. The rulings were less predictable, and they went to talk to each other about it. And they said, gee, what can we do? We can't say, did you really read the book? And they decided that the only solution was to give him a new deck of cards, which they did. The book apparently didn't do that judge any good. But there is a book out that somebody has read, lots of somebodies, I think, and if you fall asleep during the part of my presentation and you go out and buy John Gresham's book, The Appeal, to read on the plane on the way home, you will have in a fictionalized and more entertaining mode what has happened in Wisconsin for the last 2 years. It is not a pretty picture. The gist of it is that last year we had a vacant seat on the Wisconsin Supreme Court, and the lineup of the two women who ran for it were supported by about as traditional a partisan, although not identified as such, but sort of the usual players from the Republican camp supporting one, the manufacturers and commerce, that business kind of group, and the usual players on the Democratic side supporting the other. And the manufacturers and commerce spent over $3 million in issue ads talking about, tell Judge Ziegler what a wonderful job she's doing, tell Clifford why you don't want her on the bench, that kind of thing, the issue ads that we've all seen. And Judge Ziegler won by a substantial amount. The folks supporting her opponent spent probably $1.5 million, if I'm remembering my history correctly. They were outspent basically 3-1. This year, we had a race that was the first ever African American on our Supreme Court. He had been appointed 4 years ago by our governor. Before that, he'd been a trial judge. Before that, he had been a public defender. He was a very intellectual, very bright, very well-spoken, even dispositioned guy. You would not have recognized this man, who I have known for many years, from the ads that were run. And the ads that were run were actually quite amazing. Let me back up one brief step and tell you that prior to that election campaign occurring, amazingly, all 7 justices on the Wisconsin Supreme Court signed a letter to the legislature before the Supreme Court race began, urging public financing because the public was generally so sort of out of sorts about the tone and the sort of generic nastiness of the Supreme Court race that was going on in the Ziegler-Clifford race. I will tell you that was nothing compared to what we had just been through. This race, to borrow from the Gresham book, it appears that the business interests, according to newspaper reports, found a judge candidate after having made several various attempts. They found a judge who was in a very small county in northwestern Wisconsin. The population is very minor. It's a one-judge county. He had not run for public office before except for, no, he had, I'm sorry. He had been a district attorney on the other side of the state in an equally small county after getting out of law school. And Judge Gableman, who no one in the legal community particularly had ever heard of, no one in the political community that I'm familiar with had ever heard of, became the candidate that got into the Supreme Court race against Justice Butler. The ads that ran got so bad and so nasty that the Milwaukee Journal, which is the state's largest newspaper, actually ran an editorial condemning them for race baiting, the ads that were run on behalf of Judge Gableman, calling for them to be withdrawn, pointing out the inaccuracies. And those of you who are old enough to remember the famous Willie Horton ad in the Dukakis campaign, that's what we had. And we had a steady diet of almost exactly that kind of thing. There were more jail doors that slammed on our TV screen for the 3 weeks before the election than you can ever count. It was pretty bad. The folks that were supporting Justice Butler were also not doing us any favors as an electorate. They had a bobblehead ad of Gableman that basically had the bobblehead sort of nodding, and so the background was saying, various things about how he let sexual predators out and didn't prosecute, and it was generically awful. You would have thought that there was a race going on for being the county prosecutor in a high crime area. That's the tone of that race. And although Gableman won, he suffered from an editorial cartoon, I don't know how many of you can see it, where the name calling got so bad that the Gableman forces were calling Justice Louis Butler Loophole Louie because he used a provision of the Constitution to release a client when he was a public defender 20 years before. And the garbage mouth came from the newspaper. That was not Butler or the folks supporting Butler's doing. But this is a fair taste of the kinds of things that we went through. According to the Brennan Center for Justice, which I think you all know about from New York University Law School, they described the ads generally as, quote, so racially offensive that editorial boards across the state called for Mike Gableman to take the ads off the air. Gableman won by about 20,000 votes. When the numbers came in, it appears that approximately 9 out of every $10 spent in the entire campaign were spent by not the candidates, but the special interest groups. The special interest groups doing the issue ads, and I have to kind of use those in quotes because all they do is omit the magic words of vote for or vote against. Otherwise, they are absolutely campaign ads by any kind of criteria I have ever seen. But the full figures are not quite in, but it appears that about $3.2 million was spent by the interest groups on each side, not 3.2 each side, about, if I'm remembering the numbers right, about 2.1 or 2 on behalf of Gableman and about 1.6 on behalf of Butler, and the two candidates between them spent about $500,000 each. It seems to me there's something a little wrong with this picture. It got to the point where both candidates were actually saying, stand down, let us get our own message out. It didn't do any good. The ads continued, and they continued with a substantial barrage, particularly at the end. Now, that caused some folks to wonder, where is all this money coming from? Some of the issue ads were identified as coming from specific groups. Some of them were identified, if at all, as coming from groups nobody had ever heard of, but that have a nice kind of generic name. You know, not Citizens for Good Government or, you know, but something really sort of innocuous, and it tells you nothing about who's actually paying for it, et cetera. There are some campaign finance reporting rules, though, and large contributions near the end, which is where most of the money is spent, and most of the money is spent on television, because we all know that's where people get their information primarily, and this is the only race that was going on. It was the top of the ticket, and the airwaves were saturated. But it turns out that a New York resident by the name of Paul Singer, and apparently his son, and apparently his wife, and a woman who's a financial officer in his company, and a trust of his, each contributed within the last week $10,000 to the Gableman campaign. Now, you got to wonder what somebody in New York is doing in a Wisconsin Supreme Court race. This man has no connections to Wisconsin. It isn't his grandma's hometown or anything like that. And so if you follow some of those trails down, what shows up is that special interest groups, apparently on both sides, are developing national networks to fund either attacks of or defenses of Supreme Court justices in states where there are justices up. I'm not opposed to free speech, but I'm very worried about how the judiciary is perceived when the folks who are the candidates can't control the ads and what's being said and the nature of the attacks, where you can't meaningfully regulate any of it, where perhaps the most you can do is require reporting so that at least people after the fact know who contributed the money, but I'm not sure how much good that really does. So we're left with a situation where the bad taste in the mouth of the Wisconsin voters about the race is overwhelming. Everybody hates negative ads in most places, but at least in the kind of partisan politics that is real politics, if you will, where you're electing people to the state legislature who can make policy, where you're electing people to governorships and things of that nature where you can make policy, there you can legitimately argue the issues. In a judicial race, you can't say, oh, but I put so-and-so in jail because, or, those are just the kinds of things that don't lend themselves to public discourse. And so we had a barrage of code words. And one judge was saying, I'm not an activist judge, I'm a judicial conservative. And the other judge was not talking about that at all because it was code saying all sorts of things. So is my time already up?
We're approaching it.
We're approaching it, all right. So what has happened now is, after all the code talk, the only good thing coming out of this, to my way of thinking, is that there is now a lively debate in Wisconsin about, keeping in mind that we're a state that has elected judges since we became a state, about whether this is the right way to go, at least for our Supreme Court. There's a proposed constitutional amendment that would have the governor appoint, that the appointment would be for, I don't remember what period, 5 years, 10 years, and that the appointment would be confirmed by the state Senate. And the initial interest, that has to be confirmed by the state Senate, much like the federal system. And at the end of that period, the judge is automatically reappointed unless 2/3 of the Senate vote to remove. So that there's still an electoral kind of an accountability, but there's not the sort of general populace election. And that's driving some talk show hosts nuts about taking away rights to vote. The Court of Appeals Chief Justice has proposed a very complicated kind of commission that is basically to bring all the players to the table, the people who usually do the issue ads and the Senate and the Assembly and all those folks, bring them to the table as a commission, have them pick 3 people, send those names to the governor has to appoint from that list of 3, and then in the 5 years when the fellow has to run, presumably because of all of the people that bought into it, there won't be a big opponent. But his second piece is, and this is the financing, if there is an opponent, the state should match dollar for dollar every dollar the special interests put in so that there's an even playing field. I have yet to be able to understand how you can physically accomplish that because you don't know how much is going to be spent until the election is over, and then it's too late. So Wisconsin is living in one of those interesting times. The nature of the debate that is now going on is phrased sort of like this. On our editorial page this last Sunday, elect or appoint, and the part of it that really troubles me is how many people actually believe the judge for sale notion is now what's going on. I think the integrity of the judicial system is at stake in what's going on across the country now.
Thank you. I would note that in 2005, a study at Syracuse University found that of those voters most interested in both hearing about and participating in judicial elections, the media coverage was the heaviest in those areas. And so from the First Amendment Center standpoint, where we monitor what goes on with the free press, it is a chicken egg to some degree, but when there is press coverage intently, there is great public interest, but also the most support for elections of judges as opposed to appointment. So it's an interesting dichotomy there. Judge Ruiz.
Thank you. I don't have a joke prepared. Not yet, maybe.
Probably good.
Something will come up. I have the luxury, unlike Judge Kessler, of speaking as a judge who has not had to go through an election, nor have I been personally exposed to the excesses that she has just been telling us about. I'm a judge of the District of Columbia, and you will be interested to know, Judge Kessler, that our system of appointing judges is somewhat like what is being proposed in Wisconsin. The courts of the District of Columbia are in virtually every respect like a state court system. I sit on the Court of Appeals, which is the court of last resort within that system, with review only in the U.S. Supreme Court. I have gone through a selection system that includes a first round by a statutorily created Judicial Nominations Commission, which represents various constituencies, the mayor, the city council, the D.C. Bar, the federal courts, and the president. That commission takes applications, interviews candidates, vets them, and recommends 3 to the White House. From among those 3, the president selects 1. And that presidential nomination is then sent to the United States Senate for confirmation, not in our case by the Senate Judiciary Committee, but by the Governmental Affairs Committee. We have 15-year terms, not life, but certainly longer than 5. Not the usual route for essentially a state judge, but this is the nation's capital, and this is not the only way in which our court system combines local and federal aspects. For example, the same U.S. attorney prosecutes criminal cases under D.C. laws in the D.C. courts as does in federal crimes in federal courts. I can't say that I regret not being an elected judge. I don't think I would like to go through a campaign. I would like, however, to present some views that perhaps you would not expect from an appointed judge. As we know, there are many elected judges who are excellent jurists, and yet there are also appointed judges who are lacking in some of the qualities we would like to see in judges. So the manner of selection is not necessarily a guarantee of excellence, nor a detriment to that result. And there certainly are some benefits to the exposure to the electorate's exposure to the judicial candidate, and the voters' knowledge that they have elected a judge that is very positive for democracy and democratic values. Judges are, after all, entrusted with great authority to make decisions that have a profound impact on people's lives, and it is important for the public's confidence in the judiciary that they know and they trust the people who serve as judges. Wisconsin Chief Justice Shirley Abrahamson, for example, has given a very thoughtful speech on this subject at the Brennan Center, which is reprinted in the NYU Law Journal, about the important educational benefits that can accrue from judicial elections in a manner that is not as likely under an appointive system. She has outlined the problems in an electoral system of judicial selection to be uninformed voters, campaign financing, we've heard about that, and the regulation, or rather increasingly the deregulation of campaign conduct by judicial candidates. So the problem may not be selecting judges by election, but the thinking and the perception that go with it. That particular groups can put their judge on the bench and basically own that judge, bought and paid for, especially when it's combined with the toxic influence of big money judicial campaigns. That is something that could be addressed in part by public financing of judicial campaigns. More worrisome, I think, are the results of recent studies that perhaps judges themselves think that they are influencing their decisions by who contributes to their campaigns and by who makes the bigger contributions. And the erosion of judicial codes restricting what judges may say in the heat of the campaigns after the Supreme Court's opinion in White adds fuel to the concern that judges may not in fact be free or be perceived as able to consider cases impartially and fairly once they assume the bench. The ABA's recent revisions to the Model Judicial Code recognize as such by requiring disqualification when a judge, either as a judge or as a judicial candidate, has, quote, made a statement other than in a court proceeding, judicial decision, or opinion that commits or appears to commit the judge to reach a particular result or rule in a particular way in the proceeding or controversy. But if recusals, whether for money received or statements made during campaigning, are to be the answer, who's going to be left to decide the cases? People are so compromised. Could there be a risk that we will see preemptive contributions to judicial campaigns in order to force disqualification, just as there have been preemptive retentions of prize counsel in order to create a conflict with a competitor? Whatever the drawbacks of money-backed judicial elections, and there are many, we should not fool ourselves, however, into thinking that an appointive system, sometimes loosely mischaracterized as a merit system, as currently structured, is a perfect alternative. nor should anyone be misled into thinking that an appointive system is somehow free of politics, nor frankly should it be in a democracy. For those with high stakes in the composition of the courts, there can be much behind-the-scenes lobbying. Sometimes I'm informed by paid lobbyists representing interest groups. But it takes place not in highway ads and TV spots vying for the public's attention, but in the context of more polished and subtle presentations in politicians' offices. At least there, the money does not pass through the prospective judge's hands. But if the judge knows who is promoting him or her, does it make that much of a difference? And does the absence of the public's knowledge about these efforts make it any less political, or simply less democratic? So at the same time that the debate goes on about the noxious effects of judicial elections, which might lead to more jurisdictions adopting an appointive system, we should not lose sight of the need to improve on the current system for appointing judges and for the standards that judges who are the product of that system should observe. Many of the evils that we note in the elective system find a contrary weakness on the appointive side. If elected judges are suspected of being beholden to the voters who elected them, appointed judges are criticized, not for being beholden, but for being aloof, arrogant, and disconnected from their communities. If elected judges are unfairly subject to punishment at the hands of voters for unpopular decisions come re-election or recall time, as happened to Judge Penny White in Tennessee, voters fear that appointed judges, particularly those with life tenure, may stray too much from what they believe are mainstream American values and attitudes. Appointed judges have very little feedback and evaluation other than what the judicial system itself provides in the form of appellate review. But that means that there is almost none for those on the highest state courts or federal appellate courts. Appointed judges who are sensitive to this absence of criticism and oversight and who understand the need that their decisions be viewed as legitimate may overcorrect and cling to literal and strict construction of law as a way of showing that their decisions are not subjective. That is not necessarily a welcome development. And there is the issue of diversity. Judge Kessler has just told us about the recent experience in Wisconsin in which an African-American judge was lost on the Supreme Court. But whether elections as opposed to appointments yield greater diversity needs to be studied in more detail, and the results may not be the same across the board. I'm happy to see that Drew Ramey, the executive director of the National Association of Women Judges, is here, because she may be able to give us some information about whether women candidates in particular may fare better in states where judges are elected, to the extent that judges are sometimes angry and want to vote out the usual suspects. The fresher face, the newer person, may well be the one who has not traditionally been represented on the court, and that may well be a woman or a minority. So that is something to keep in mind. Fortunately, there are ways in which the appointive system can be improved, and some are being discussed. With respect to judicial aloofness from their communities, the revised ABA Model Code of Judicial Conduct now provides in a comment to Rule 1.2 on promoting confidence in the judiciary that, quote, a judge should initiate and participate in community outreach activities for the purpose of promoting public understanding of and confidence in the administration of justice. Consistent with that goal, the Model Code has also relaxed somewhat judges' participation in educational, religious, charitable, fraternal or civic organizations and activities in their communities, particularly those that are law-related. This includes attending fundraisers. Although decisions are always to be made on a case-by-case basis, taking account other provisions of the code with respect to conflicts with pending cases, public statements, and the appearance of impropriety, it is an important signal that the code is not only about what a judge may not do, but also about what a judge should be doing in terms of the broader community in which he or she sits. it is very significant, I think, that the code drafters thought it important to stress, not only in a comment, but in a new rule, Rule 3.7b, that, quote, a judge may encourage lawyers to provide pro bono publico legal services. That tells you something about the mindset of some judges, that they felt restrained from doing that in a general way. The system of self-regulation and self-discipline is troubling to many who see the judiciary as unwilling to address judicial misconduct, from sexual harassment in chambers to intemperate and offensive behavior in court. The system is many times confidential, and the findings and sanctions, if any, are not always publicly known. This is something that courts need to address if they are to maintain that public oversight at the ballot box is not required to keep the judicial house in order. Similarly, recusal policies and procedures must be addressed, particularly the practice of having the very judge who is the subject of possible disqualification make the decision whether to recuse without necessarily having to disclose the reasons why, and without a process of plenary review, or any review in some cases. The subject of standards and procedures for recusal is being highly debated in the context of the increased potential for bias resulting from judicial elections, but it must also be comprehensively addressed if the public is to be persuaded that an appointive system is a better alternative to the voters' selection and oversight. Judges should be evaluated, but care must be taken that they're not merely either praised to the skies by those who have won before them or damned to hell by those who have lost. Volunteer observers from the community can be tapped, for example, as a resource to observe judges' demeanor in court, if not to review the substance of their legal rulings. The Council for Court Excellence here in the District of Columbia, for example, following the model of the Fund for Modern Courts in New York, has engaged in a comprehensive evaluation of judges on both the Superior Court and the U.S. District Court here. In closing, let me say that I think of judicial independence as a state of mind. A judge must have the clarity of mind to know that her one and only obligation is to apply the law to the best of her ability to the case before her, having the necessary resources to do so without favoritism or dislike towards either party. Judges are sometimes called to be counter-majoritarian, but if their decisions, especially the most controversial and unpopular ones, are to be respected as fair and complied with as legitimate, the process of selection of judges, the code that governs judges, and the institutions in which judges must operate must permit that mental space for judicial independence. But it must do so without falling into practices that are at odds with the basic democratic thrust of our society. All I posit is that there isn't any one way to get there. Thank you.
Thank you. I would, just to put this in very quick perspective, point out that in the 1780s, those who favored the election of judges noted that in the Declaration of Independence, it was noted that the magistrates of the time were beholden to King George, and with all sorts of evils as to the control of their liberty, their salary, and their jobs. And the contrary argument was that, as I believe Hamilton phrased it, appointments were necessary to protect judges from legislative whims and ill-humored persons. So with that, Mr. Rutledge.
Thanks, Gene. I wasn't on this panel 24 hours ago, and my executive director came to my office at about this time yesterday and said, I'm losing my voice. I may not be able to do this tomorrow. I'll let you know in the morning. So sure enough, this morning he'd lost his voice. So I realized I had to pull something together. The first thing that I did was log on to the Washington National's website to see how they're doing, how my team is doing this year on pinch hitting, since I was going to be pinch hitting. And they're hitting 3 for 31 in pinch hits, which is under 100 batting average. So hopefully I'm going to do a little better than that today. A few other notes on the Wisconsin issue, and I sense that there's a little bit of a debate emerging here, so I'm going to try to move quickly. As Judge Kessler was observing, just to quantify a little further, there were over 11,000 television ads that cost over $3.5 million run in this most recent campaign. 89% were paid for by special interest groups. Our group has been studying the influence of money in TV on judicial races for several years now, and I don't believe we've ever seen one race where there were 11,000 TV spots aired in one campaign. It was truly phenomenal. So, why does any of this matter? I think we all have a good sense of why it is. Our group did a poll of Wisconsin voters in January of this year. This is before the campaign started. We wanted to sort of get a sense of where people were on these issues. And we found that 78% of Wisconsin residents were under the impression, or at least the perception, that campaign contributions do have an influence on the decisions that get made in the courtroom. You can imagine what that number would be if we'd asked that polling question in the heat of the campaign. The other point that I would make about what we saw in Wisconsin was the remarkable lack of voter turnout. On February the 19th, Wisconsin had a presidential preference primary. 6 weeks later, they had a Supreme Court election. Fewer than half the voters that voted in February came out in April. You can attribute a lot of that to the normal disinterest in judicial elections, and I think you can attribute even more of it to people being completely disgusted by what they saw. Even if they did go out to vote, they may have just decided not to vote for the Supreme Court race. If anything, Wisconsin is coming to this national party a little bit late. Candidates across the country for state Supreme Courts have raised $165 million this decade, compared to $62 million in the 1990s. In the election year 2000, TV ads appeared in 1 out of 4 states with state Supreme Court elections. In 2000, they appeared in 9 out of 10 states. Fundraising and television advertising records are being set and reset with every passing election cycle. The Wisconsin campaign that we just have concluded captured a fair bit of national attention. There was an editorial column on the New York Times editorial page the other day. One of my favorite turns of phrase I've ever seen was in The Economist recently, which referred to the campaign as habeas circus. And it has also garnered some attention from the editorial page of the Wall Street Journal. The Wall Street Journal editorial page, as probably most folks know here, generally embraces most things free market. It certainly embraces free market elections. And they have been very critical of merit selection systems that have been discussed here. And so this is how one editorial writer for the Wall Street Journal describes merit selection systems. Intended to keep politics out of judicial appointments, judicial commissions have become agents of politicization themselves, steadily tilting state court systems to the left. There's obviously a fair amount of hostility towards abandoning elections entirely. It's also important to note that if we're going to look at merit selection or some other form of commission-based appointment system as an alternative, that this is a very difficult reform to achieve in American politics. In fact, I think it's probably one of the trickiest bank shots to accomplish anywhere in the country. The last state that actually constitutionally divorced itself from contested elections was Utah in 1985. In other words, the U.S. Constitution has been amended more recently than any state constitution has been amended to do away with judicial elections. Where merit selection systems do exist, they are under fairly steady attack, including from the editorial page of the Wall Street Journal, but also on blogs across the country and in the states. In Missouri and in Kansas, there are efforts to reshape who sits on the commissions and to require Senate confirmation of judges. Right now, those are not parts of the merit selection system. Both avenues are essentially intended to achieve more overt political control over the appointments. In Arizona, Indiana, and Tennessee, there are proposals to replace the merit selection system with partisan contested elections. In other words, to go back to a system like we see in Wisconsin. These attacks are not limited just to systematic processes by which we choose judges. We're seeing an increasing number of very political attacks on judges and judges' rulings directly. Our group also tracks the number of threats, rhetorical threats, or impeachment threats directed against state judges. Between 1986 and 1990, which is the furthest back we look, we found 19 impeachment threats leveled against state judges. In 2001 to 2005, that number went from 19 to 53. Threatening judges is good business in certain trades, whether that may be the media, Nancy Grace and Bill O'Reilly, who owe their accountability to ratings and advertisers, political consultants who would like to see fast money being raised off of the latest controversial decision. And all of this sort of feeds what we describe as a growing outrage industry against judges who are very easy targets. I know we're behind on time, so I think I'll leave my comments there and reserve the rest for discussion.
Very good. Thank you so much. And we'll move right to Mr. Payback.
I'm going to talk about selection of judges in the context of capital punishment. And one example that I want to start with is the Texas Court of Criminal Appeals, which is now frequently reversed on death penalty cases by the Supreme Court. One reason for that is that they have done things like find no problem with lawyers who sleep through trials and other such things. One of the elections that they had, which illustrates what can happen in a contested election, was when Judge Charles Campbell, who was a former prosecutor who had been on the bench on that court for 12 years, was part of a ruling reversing on relatively clear legal grounds that weren't particularly controversial, the death sentence of somebody who had killed a police officer, which then attracted fire. So he was then opposed by one Stephen Mansfield, whose campaign platform included more use of the death penalty, greater use of the harmless error doctrine, and sanctions for filing frivolous appeals. He admitted during the campaign lying about the state in which he was born, his past political experience. It was revealed that he had virtually no criminal law experience, that he had been sanctioned for the state of Florida for practicing law without a license, and he got 54% of the vote, which caused the Texas Lawyer magazine to say he was an unqualified success. Sharon Keller, who is now the presiding judge of that court, promised on the campaign promise that she would never, ever reverse the death penalty case, a promise she has kept. And she got some notoriety and a lot of press attacks this last year when she refused to grant a stay of execution after the Supreme Court had made it clear it was going to take the consideration of a lethal injection case, and the lawyer's computer broke down and were trying to put that into their stay application. She refused to keep the court open any longer, and she didn't even tell the judges who were supposed to consider the stay application that she did it. Now, there are also can be problems with retention elections when you don't have an actual opponent, but you are up and the voters vote up or down. One early example involved Cruz Reynoso and two other judges of the California Supreme Court who were denounced in a major campaign that focused on their votes in death penalty cases. However, it was later shown that this campaign was financed by business interests who were actually upset at their rulings in consumer law cases, but were using the death penalty as a way to get them off the court, and they succeeded. Penny White was mentioned earlier. She was a justice of the Tennessee Supreme Court. She sat on exactly one death penalty case in which she was part of a 5-judge majority that affirmed a unanimous reversal by the intermediate appellate court of the death sentence, not the conviction. She was part of 3 judges who said, by the way, they also doubted that the heinous, atrocious, and cruel standard in the statute had been met. This got no attention at the time, but 6 weeks before her retention election, her vote in that case became the major issue against it. The Republican Party ran ads saying that if you're for the death penalty, vote against Penny White. She was defeated by 55% to 45%. And afterwards, the governor stated, should a judge look over his shoulders in making decisions about whether they're going to be thrown out of office? I hope so. Later on, Judge White was teaching a course at the National Judicial College in which she was teaching the judges with a hypothetical where it was clear under binding law that you had to grant a motion for a defendant. And the judge that was the student in this class kept ruling against the motion. So the third time he did this, she said, why are you doing that? said, well, the appellate court can worry about it. I will keep my job. You have lost yours. Now, we then have certain systemic effects that can take place. Studies in Alabama where judges can overrule for no reason juries that vote for life sentences in death cases have shown that there are more overrides in election years than at any other time, and the closer you get to the next election. There's also been shown in national study by Gerald Ullman that the affirmance rates in death penalty cases in state courts are correlated with the methods of judicial elections. A 1995 study by Melinda Hall showed that elected Supreme Court judges are more likely to affirm in death penalty cases in the 2 years before the ends of their terms when they're up for a new vote. And in a 1997 study of Democrats who are judges, that those who had short lengths of term had many fewer votes to reverse death penalty outcomes than those who had longer terms, and that all of them who were elected were less likely to throw out death sentences than appointed judges were in conservative states. Now, this is not to say that appointive systems are a panacea. You may remember that when John Ashcroft was up for confirmation as Attorney General, he was attacked for having prevented Missouri Supreme Court Justice Ronnie White from getting confirmed as a federal district court judge, who had been promoted by the other Republican senator from Missouri, Kit Bond. The claim was that he had done this because Ronnie White was African American. He said, no, didn't do it for that reason. I did it because Ronnie White voted frequently to overturn death sentences. Now, again, no discussion of why he voted in the minority of cases that he voted not to affirm death sentences. What was the Constitution? No, it was just because he did it. And that was the defense that Ashcroft offered. And the fact that he usually affirmed death sentences and that judges that Ashcroft, when governor of Missouri, had appointed to the Missouri Supreme Court, had thrown out just as many death sentences as Ronnie White, somehow did not get mentioned. And then when the Republicans took control of the Senate in 1995, Senator Hatch, as the chair of the Senate Judiciary Committee, made it clear that he was going to make support for the death penalty a litmus test in whether he would confirm judges. And Steve Wright, in a program that we did a few years ago, cited an example of an Alabama trial judge who was awaiting confirmation as a federal district judge, who was asked to override a jury vote of a life sentence in a death penalty case. And despite all kinds of mitigating evidence and the fact that the murder victim had murdered the defendant's brother, among other reasons why you might uphold the jury's verdict of a life sentence, this judge overrode the jury and put in the death sentence, knowing that the Senate confirmation might depend on it, particularly with Senator Sessions taking a similar view to Hatch. Rosemary Barquette would never have been confirmed to the 11th Circuit and probably would not have been appointed by President Clinton if the Republicans had already taken over. She already had 30 votes at least against her. Again, it was because even though she affirmed as the Chief Justice of the Florida Supreme Court most of the death sentences, she voted more times than some would like to overturn death sentences. And then you can get not confirmed because of doing pro bono work. Jeffrey Coleman, a prominent partner of Jenner and Block, was up for a federal district court nomination, and he could not get to first base in the Senate Judiciary Committee because he had successfully represented a death row inmate pro bono and had done some other pro bono work. And there are other ways, even aside from elections, that judicial independence has been threatened because of the death penalty. In one sad instance, prior to the Florida Supreme Court's having oral argument in a case about their Death Penalty Reform Act, the chair of the House committee in Florida in charge of court appropriations sent a note to members of the court saying, your decisions continue to be a mockery to the victims and their families. But to end on one positive note, there can be one good effect of judicial elections, which is that you, once in a blue moon, can get your relief for your client based on it. I had a death row inmate I was representing pro bono in Alabama who we had gotten the right to have a new sentencing trial. The trial judge, Judge Inga Johnson, was going to be the sentencer, and as I've mentioned, regardless of what the jury did, she was going to be the real sentencer. My client remembered that after she had sentenced him to death in the first place, she had run a campaign ad saying, "Vote for Inga Johnson because, among other reasons, I sentenced this scumbag, my client, to death." So we said she should recuse herself. And she said, "No, I'm not, there's nothing wrong with my sitting on this." So we made a mandamus motion, and the appellate court ordered briefing. Well, at that point, she ordered all the counsel, and she said, "Well, I am, this is ridiculous. They're never going to uphold this recusal motion. But as a sentencer, I'm going to predict to you that because your client has done such a great job in prison, he's gotten his GED, I am predicting, although you can't hold me to this, that I will sentence him to life without parole, not death. So therefore, District Attorney, please settle the case." And he did. So this is one happy result of this otherwise tawdry situation. Thank you.
It's always good to have a positive moment.
And
there.
she later
Thank you.
has been appointed and confirmed as a federal district judge.
Well, we do have a few moments, although there are some airplane connections, I know, for some of our panelists, but we have a moment for questions. I would just observe also, for those of you who are interested, perhaps while you're moving to, or if you have a question, that on our website at firstamendmentcenter.org, we also discuss some issues relative to speech and conduct. Once one decides you either are in a partisan election or in a retention mode or what have you, as Justice Scalia is interpreting Brother Hamilton and Madison and the rest, so in occasional decisions. Do we have questions for our panel members? We do? I think if you wouldn't mind, well, I think to be picked up on the recording, unfortunately, so thank you very much.
Thank you. I'm Shelley Hayes, and I'm in the District of Columbia. And I don't have a question as much as a comment. This has been a very enlightening experience for me because we have appointed judges in the District of Columbia. I can say from personal observation that with respect to diversity on the court at all levels, the appointed system seems to work. Our judiciary in the district, in the local court, the Superior Court and the Court of Appeals, seems to reflect the population of the District of Columbia. And if perception is important, if perception of impartiality and perception is fairness, I think that it has worked, the appointment system has worked in the district.
Thank you.
Just a comment on, I'm Drew Rayman, sort of California. Anyway, but you don't have to be a conservative Republican to sort of prove what some of the, when Gray Davis was the governor of California, he had a pure litmus test on the death penalty. And I just wanted to give one anecdote that gives you some idea of what Democrats can do on this. And that is, I was listening, sort of because I had already been dinged for a judgeship because of my death penalty situation. And this one guy went up to the governor at a cocktail party, and I was just a fly on the wall listening to this thinking, don't do it, Garrett, don't. But he says, "Governor, I wanted you to know I've applied for a judgeship, I did this, I did that, I went to law school here, I did that." Judge says, "How do you feel about the death penalty, Garrett?" And so Garrett sort of was a little taken aback. And he finally said, "Well, and he got so flustered, he said, an eye for an eye." And then the next thing the governor said was, "You know, Garrett, I just don't hear the level of enthusiasm I'd like to hear." I mean, this was a Democrat.
We have anyone else? Any closing thoughts from our panel? Oh, beg your pardon. We have a question here. Forgive me. Wait for the microphone if you would. Okay.
We all know that when they say I'm going to appoint a judge who interprets the Constitution with its original intent, what that's a code for. At least I know what it's a code for. But has anyone ever heard someone that I would not interpret the Constitution as the original intent of the founding fathers? That frightens me. But I wouldn't be frightened, but I've never heard, I will appoint a judge that interpret the Constitution as the original intent of the constitutional framers of the Reconstruction Articles. Has that ever been proposed? Okay, one question.
Stump the panel, I believe, is the moderator's position. So,
What is judicial activism more a predilection of conservative judges or liberal judges?
It depends what you mean by judicial activism. The fact is that, in my opinion, the Supreme Court under Rehnquist and Roberts has been extremely activist in trashing the Constitution, in inventing all sorts of new procedural barriers to meritorious claims, in reviving doctrines that have come out of nowhere, in invalidating statutes that were passed properly, by resuscitating doctrines that had been thrown out 50 years earlier. So in my view, they're about the most activist court we've had in a very long time.
Ron, I'm glad you were equivocal about that. Gene, if there are no other comments, I would like to thank this panel. I would like to thank this panel first. You'll applaud a couple of times, I hope. Also to thank all those who spoke at the earlier panels and breakout sessions, and thank you who have stayed through to the end. It was a most enlightening day. I learned a lot from it, and I thank you all for coming. And on behalf both of the Section of Individual Rights and Responsibilities, the American Constitution Society, again, thank you for coming, and we are adjourned.